element to grant regulatory authority over non-members, which was broadly divested.
So, Counselor, if we were to disagree with your analysis regarding the fee-like land and the parking lot distinction that you're drawing, and we find in favor of the tribe vis-a-vis the status of the land, are you saying that your client's membership status would trump the status of the land? Because you just conceded that land is a factor that we should take into consideration.
No, Your Honor, I would not say that the membership status would trump. I would suggest that it's a departure from Supreme Court precedent for this court to hold a non-consenting defendant to tribal regulation. However,
but where does the term consent come into it? Montana create a consent-based test?
And Montana does
the consent of the parties?
No, what I'm referring to is a situation like that appeared in the Williams case, where the non-member was a consenting party, where he was the store owner who operated the store on trust land, and so he consented to tribal regulatory authority because he operated his business on trust land. That's a lot different than what happened with this situation. So I'll move on to the Montana exceptions, where the Williams case was cited by Montana as a case that would pass the first consensual economic relationship test of the Montana exception. That was a prolonged economic activity, and we argue that in order to pass the Montana exception, you have to have a prolonged economic function. Going to a casino and gambling once.
Before we get into the exceptions, before we can even determine and get to these, Montana applies to a matter that occurred on trust land.
Yes,
because the Montana decision the facts there did not involve trust land. So is your contention that Montana applies to a case like this, where it is trust land?
No, our contention is that Montana applies when necessary to control the internal relations or to threaten the self-government of the tribe. And as Justice Kennedy rationalized in his dissent in Montana, a self-government or a regulation over non-members is not necessary for the self-government of the tribe, for the tribe to make its own laws and be subject to them, or to control internal relations. And so they drew the Montana exceptions where that would always be the case. So we're arguing that it would be a departure for this case, for this court to hold a non-consenting defendant to tribal authority, and that even if you did want to, that the tribe wouldn't be through the Montana exceptions.
Well, what are the Montana exceptions about? I mean, they're about holding accountable people who are not tribal members.
Yes,
so
Your
you
Honor.
seem to be arguing in a circle, but we're sort of foreclosing the possibility, any possibility that the tribe would have civil jurisdiction over their client.
The Montana exceptions define two scenarios, multiple scenarios, but two indications where a non-member's conduct would threaten self-government or endanger internal control of the tribe. And they drew those two exceptions, where the tribe would always have regulatory authority. But our petitioner's conduct did not threaten the very subsistence of the tribe, which the Plains Court ruled would be necessary in order to qualify for the second exception. And it is not the prolonged type of economic activity in order to qualify for the first exception. However, in order to...
Where do you get the word prolonged from? Does the word prolonged appear in Montana?
No, Your Honor, it does not. It's my analysis of the cases that have passed the Montana exception. This is all.
You're talking about prolonged. Prolonged can be 3 seconds. Prolonged can be 2 years. You know, what's the test? If you want us to add a prolonged factor, how are we going to gauge that factor?
I don't know how to draw the broad line. What I do know is that the straight case was not enough to qualify for this, and that was when a contractor had the permission to be on trust land for an extended period of time, and that still was not enough of an economic relationship.
Again, you're going back to the status of the land. You're conflating the membership issue and the status of the land. You need to first deal with the status of the land with straight, which you have not yet adequately addressed my first question regarding how do we get to the Montana exceptions if this is trust land. So you need to first deal with the question of land. That's straight before you can get to the Montana exceptions. And then keep in mind that the Montana exceptions are two separate extensions. You have the consensual relationship, and then you have the impact on the health and welfare. So you need to deal with those separately.
Okay. Thank you, Your Honor, for the clarification. Relying on our argument, we would suggest, may I continue for a moment?
You may briefly conclude.
The conduct where the petitioner, that brought us to this court, if you're only arguing is fee-like land. Therefore, we're saying that the land status is not a significant factor because it's fee-like. Secondly, this would be a departure for the case to apply the petitioner to the tribal regulation because he is a non-consenting member. And once we've addressed that issue of the land, then we can see that the Montana exceptions do not apply because it does not pass the increased threshold necessary for the exceptions. Thank you, Your Honors.
May it please the court, my name is Brianna Coyle, and I'm here on behalf of my client, Larry Manitowoc. Judge Chippewa's civil contempt order is illegitimate for two reasons. The first is because the Rabbit River Tribe lacks adjudicatory authority over Manitowoc, and second, because the order deprives my client, Mr. Manitowoc, of
Counselor,
critical
your
due
co-counsel
process.
is talking about regulatory authority. Can you please describe for this court the difference between adjudicatory authority and regulatory authority?
Certainly, Your Honor. Regulatory authority is the ability to regulate conduct, so it would be to issue a citation. Adjudicatory authority is the ability to enforce those laws, to enforce them. So to bring them, haul them into tribal court and to preside or adjudicate over that matter.
So then in this matter, since you're discussing only adjudicatory authority, would you say that the tribal court here had the regulatory authority to issue these orders? It's just whether or not they have the right to enforce it?
I will be addressing both circumstances. So first, arguing that Strait held that a tribe's adjudicatory authority over a non-member does not exceed its regulatory authority. So regulatory authority is a prerequisite before you can get adjudicatory authority. But second is that even if the Rabbit River Tribe has regulatory authority over my client, they still lack the necessary adjudicatory authority for the civil contempt order at issue for that to be executed.
Wouldn't the second type of authority be implied? If there's regulatory authority, you need to have the other authorities. Otherwise, that it's not worth having the regulatory authority. Wouldn't you agree?
No, Your Honor. I think that there is certainly a connection between the two, but that when we look at precedent, is that it's not clear that the decision in Strait says that they don't equal each other, that they don't necessarily come together. So we have to look at a different test in order to decide whether or not there is adjudicatory authority. The test for whether or not there is adjudicatory authority is whether or not it's necessary for tribal self-government or internal control. So we would maintain that in this case, the adjudication over my client was not necessary for tribal self-government or internal control for three reasons. The first reason is that civil contempt orders must be absolutely necessary for self-government or internal control, and that it wasn't in this instance because if you look to Strait's analysis of State v. Schmuck, they explained that the court readily agrees that the tribe has the immediate ability to detain my client, take him into tribal court jail, but then would need to turn him over to the proper state or federal authority. So we maintain in this case that the Rabbit River Tribe could have achieved the same goals, the same security of well-being or health of their tribe by merely taking my client into their jail for overnight or until he sobered up, and then handing him over and the drugs over to the proper authority. That this immediate solution is reasonable because it allows my client to operate in a criminal system or adjudicatory system.
Counselor, just because there was another option doesn't mean that the option that the tribe chose is inherently false. What was wrong with the option that the tribe chose?
Yes, Your Honor. We believe that it's not a matter of whether it's right or wrong. It's a matter of whether or not it was appropriate. That that in Strait, we see that the test is really, the threshold is high. That it has to be necessary for tribal control, and that in this case it wasn't necessary. So in a world where jurisdiction was just open, then the tribe would have that choice. But that in this case the tribe didn't have the choice. That the rule emerges that it has to be necessary for tribal self-government. And we can see a case that exemplifies this comes out of the 8th Circuit in Attorney Processing and Investigation versus the Sac and Fox tribe. So in this case, where it was absolutely necessary, there was a raid on the tribal government, and that there were stolen documents that were critical to their economic well-being. So in this instance, there was no other alternative because they needed to get the documents back, but also it was a tort claim so they could regain, so they could get the damages that were lost. So in that sense, the remedy was necessary for tribal self-government, which is distinct from the case at hand, because in the present case, detaining my client for 15 days is in no way critical to, quote from the Montana case, to the, it doesn't in any way imperil the very subsistence of the Rabbit River Tribe, which
what if he had complied with the fines and